Rule 8. Manner of making allegations in pleadings. Section 1. In general, every pleading shall contain, in a methodical and logical form, a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party pleading relies for his or her claim or defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him or her shall be clearly and concisely stated. Pleadings must only state the ultimate facts where one relies on his defense or complaint. You must omit the statement of mere evidentiary facts. The ultimate facts refer to the essential facts of the claim. A fact is essential if it cannot be stricken out without leaving the statement of the cause of action insufficient. Settleford Realty Corporation versus CA 376-144. The ultimate facts are the important and substantial facts which form the basis of the primary right of the plaintiff and which make up the wrongful act or omission of the defendant. The ultimate facts do not refer to the details of probative matter or to the particulars of evidence by which the material elements are to be established. They are the principal, determinate, constitutive facts upon the existence of which the entire cause of action rests. Tantuica Jr. versus Republic, 204, Scra 428. Distinguish ultimate facts from evidentiary facts. What are ultimate facts? Ultimate facts are those which are essential to one's cause of action or defense. Ultimate facts refer to those which directly form the basis of the right sought to be enforced or the defense relied upon. If the ultimate facts are not alleged, the cause of action will be insufficient. How do you determine whether a fact is essential to your cause of action or defense? The test to determine whether the fact is essential to your cause of action is if the statement in the pleading cannot be deleted, because if you delete it, the statement of the cause of action or defense become incomplete. A certain element of cause of action disappears, then it must be a statement of ultimate facts. What are the essential elements of a cause of action? The following: the statement of the right, statement of the obligation, the statement of the violation, and statement of damage. You analyze a complaint from the first to the last paragraph. You find out whether the four are present. So if the statement cannot be deleted and the cause of action is still complete, then it is not a statement of ultimate facts. It is only a statement of evidentiary fact. What are evidentiary facts? Evidentiary facts are the facts which will prove the ultimate facts. They should not be stated in the pleading. They should be brought out during the trial. They are proper during the trial, but they have no place in your pleading. Evidentiary facts refer to those which are necessary to prove the ultimate fact, or which furnish evidence of the existence of some other facts. In the law on evidence, ultimate facts are called factum probandum, as distinguished from factum probans, evidentiary fact. Example, in a land dispute, the question is, who has been in possession of the land for a long time? I claim I'm the one, so I will say plaintiff has been in possession of this land continuously for the past 30 years. That is a statement of ultimate fact because that shows your right over the property, that you cannot be driven out. Suppose the lawyer wants to impress the court that the statement is true, the pleading describing continuous possession for the past 30 years from 1967 to 1997, and therefore the lawyer will now prepare the complaint in this manner. Plaintiff has been in possession of the said property continuously, openly for the past 30 years from 1967 to 1997, as may be borne out by the following. He entered the property in 1967. He cleared the property by cutting the grass. In 1968, he planted 20 coconut trees. In 1969, he planted 50 coconut trees. In 1970, he planted mango trees. And in 1971, he planted guava trees. He will recite everything from 1967 to 1997. The form is wrong because you are stating evidentiary facts. So what should be the correct pattern? Plaintiff has been in continuous possession of the property for 30 years from 1967 and up to the present. This is the ultimate fact. Then, during the trial, you present the plaintiff and you ask the plaintiff, Mr. Plaintiff, when did you occupy the property? 1967? When you first occupied the property, describe it. I have to clean it. I clean it in 1967. In 1968, were you still there? Oh, yes. What did you do in 1968? I planted coconut trees. Did you pay taxes in 1968? Yes. Where's the receipt? Here. The evidentiary fact should be brought out in court, not in the pleadings. Otherwise, your pleading become kilometric. That is what is meant by the phrase that you only state the ultimate facts, omitting the statement of evidentiary facts. Another example, in a collection case, you can just allege the defendant borrowed money and then it fell due. I made demands for him to pay, but despite repeated demands, he refused to pay. You do not have to state in your complaint that when the account fell due last November 5, I called him up by telephone, he promised to pay November 7, and called him again and he promised to pay tomorrow. Those are evidentiary facts which can be brought forward during the trial. Under Section 1, you state the ultimate facts on which you base your claim or defense. How do you state the facts? Section 1 says that statement of ultimate facts must be stated in a methodical and logical form, and you must use plain, concise, and direct statements or language. The simpler the language, the better. A pleading is not a vehicle for you to show your mastery of the English language. Use simple terms and correct grammar. The judge might throw away your complaint for not using simple language. How do you present the facts? In a methodical and logical form. It is a matter of writing style. Every person has a style of writing. Corollary. Every person expects you to write in a methodical or logical form. We have said earlier that a pleading actually tells a story. Plaintiff tells the court his story. Defendant tells his story too. Each presentation must be methodical and logical. What is the first test whether your style is methodical or logical? The best exercise is your own answer in examination. In a problem, you answer and you do not argue why. You try to present your answer in a clear manner. It must be methodical and logical. The principle is only ultimate facts should be alleged and not the evidentiary facts. Apart from evidentiary facts, what are the other matters that should not be stated in the pleading? The following: facts which are presumed by law, conclusions of fact or law, matters which are in the domain or judicial notice need not be alleged. Facts which are presumed by law. Presumptions under the law need not be alleged in a pleading. When a fact is already presumed by law, there is no need to make that allegation because your cause of action would still be complete. Example in negligence in culpa contractual. In the case of breach of contract against an operator of the common carrier, do you think it is necessary for the plaintiff to allege that the driver acted negligently? Is an allegation that the driver of the carrier acted with negligence required? No, there must be negligence, otherwise there would be no cause of action. However, there is no need to allege it in the complaint because under the Civil Code, whenever there is a breach of contract of carriage, there is a presumption of negligence on the part of the carrier. It is not for the passenger to prove that the common carrier is negligent. It is for the common carrier to prove that it is not negligent. However, in culpa aquiliana, or quasi-delict, where there is no pre-existing contract between the parties, the liability of the defendant hinges on negligence. There must be allegations of negligence. The defendant must be alleged to have acted negligently to hold him liable, otherwise there is no cause of action. It becomes an ultimate fact, which should be alleged in the pleading. Conclusions of fact or law. Conclusions of law or conclusions of fact must not be stated in the pleading. A statement of fact is different from a conclusion of fact or law. For example, where plaintiff said that he is entitled to moral damages or attorney's fees, that is not a statement of fact, but your conclusion. Statement of fact is to cite the basis why you are entitled. You must state the reason why you are entitled. The statement of the ultimate fact, as distinguished from conclusion, is explained in the old case of Matei versus Consolidated Bank, 58 Square 559. held a bare allegation that one is entitled to something is an allegation of a conclusion. Such allegation adds nothing to the pleading, it being necessary to plead specifically the facts upon which such conclusion is founded. You must plead the facts upon which your conclusion is founded. To say that you are entitled to something is not actually a statement of fact, but merely a conclusion of the pleader. It adds nothing to the pleader. For example, the complaint alleges that the defendants are holding the plaintiff's property in trust for the plaintiff without any explanation of the facts from which the court could conclude whether there is a trust or not. The Supreme Court in the case of Matai said that that statement is merely a conclusion of the plaintiff. You must state the basis of your statement that they are holding your property in trust. So a statement of law is not allowed, although there is an exception under the second paragraph of Section 1, which says, if a defense relied on is based on law, the pertinent provisions thereof and their applicability to him shall be clearly and concisely stated. Sometimes the defendant, when he files his answer, it is purely based on law. He must cite the legal provision in his answer and explain why it is applicable to him. Test to distinguish conclusions of law from statement of facts. If from the facts in evidence the result can be reached by the process of natural reasoning adopted in the investigation of truth, it becomes an ultimate fact to be found as such. If, on the other hand, resort must be had to artificial process of the law or in order to reach a final determination, the result is a conclusion of law. Herrera, Volume 1. Section 2. Alternative causes of action or defenses. A party may set forth two or more statements of a claim or defense alternatively or hypothetically, either in one cause of action or defense, or in separate causes of action or defenses. When two or more statements are made in the alternative and one of them is made independently, would be sufficient. The pleading is not made insufficient by the insufficiency of one or more of the alternative statements. The provision recognizes that the liability of the defendant may possibly be based on either one of two possible causes of action. The plaintiff may, for example, believe that the liability of the carrier may be based either on a breach of contract of carriage or on a quasi-delict, but he may not be certain which of the causes of action would squarely fit the set of facts alleged in the complaint, although he is certain that he is entitled to relief. He may therefore state his causes of action in the alternative. This provision, in effect, also relieves a party from being compelled to choose only one cause of action. What happens if one cause of action is insufficient? Will it cause the dismissal of the complaint? No. The complaint will remain insofar as the sufficient cause of action is stated. The insufficiency of one will not affect the entire pleading if the other cause of action is insufficient. Example: if you were a passenger and you get hurt, that is culpa contractual. If you are not a passenger and you get hurt due to the negligence of the driver, that is culpa acquiliana. So it depends whether there is a contract of carriage or none. In that case, the passenger was about to board a bus. As a matter of fact, the left foot had already stepped on the bus. The bus suddenly sped up. He fell. He was injured. What is the basis against the carrier? Is there a contract or none? There is, because one foot was already on it, but others say there was no contract yet. You don't really know whether your cause of action is culpa contractual or culpa acquiliana. You want to claim damages, but you are not sure whether your case is based on culpa contractual or culpa acquiliana. It's either one of the two. It sometimes happens. Now, if you're the lawyer for the plaintiff and you are tortured to make your choice, you may allege two possible alternative causes of action. You will draft the complaint in such a way that you will show to the court that your cause of action is either culpa contractual or culpa acquiliana. You will make sure that the both allegations are covered. You cannot be wrong because the law does not require you to make a choice. Pleading alternative causes of action normally leads to inconsistent claims. For instance, the elements of a cause of action based on a contractual theory are inconsistent with those of a cause of action based on quasi-delict. A suit based on a breach of contract of carriage, for example, does not require an allegation and proof of negligence because it is not an element of breach of contract suit. Calalas versus CA. FDU Insurance versus GP Sarmiento. On the other hand, negligence as a rule is an essential element of a suit based on a quasi-delict, Article 2176. Under Section 2, this situation is permissible as long as the allegations pleaded within a particular cause of action are consistent with the cause of action relied upon as an alternative. Thus, if the alternative cause of action is a breach of contract, the allegations therein must support the facts constituting the breach of the contract. Alternative defense. You are the defendant. You are confronted with the same problem. There is a complaint against you, and you have three possible defenses. Are you obliged to make a choice immediately? No. The law allows the defendant to cite the three possible defenses alternatively, meaning it is your defense or not. No matter if your defense are inconsistent, Section 2, Rule 8 allows the defendant to plead his defenses hypothetically or alternatively. They may be inconsistent with each other, but what is important is each defense is consistent in itself, meaning each defense, when taken alone, is a good defense. You look at them separately, you do not compare them. For example, plaintiff files a case against a defendant to collect an unpaid loan. The basic allegation is that the defendant obtained a sum of money by way of loan and never paid it. Here is defendant's answer. A. That is not true. I never borrowed any money from the plaintiff. That is a defense of denial. B. Assuming that I received money from the plaintiff, that money was not a loan but plaintiff's birthday gift to me. In other words, it was a donation. 3. Assuming that the money I received from the plaintiff was really a loan, however, such amount was completely paid. Defense of payment. So I have three defenses. How can you reconcile these three defenses? They are inconsistent with each other, but it should not be taken against the defendant. What is important is that each defense is consistent in itself. Look at them separately. That is also called a shotgun answer. The rule allowing alternative defense is consistent with the omnibus motion rule, which requires that all motions attacking a pleading shall include all objections then available, and all objections not so included shall be deemed waived. However, during that trial, you have to choose among them which you think is true based on evidence. The problem is that you choose one, but it turned out that a different defense would be correct. You cannot use that defense anymore. There is a prejudice because during the trial, you will choose among them with the defense you have. You can abandon the others, and that is even better because you might confuse the plaintiff of what really is your defense. Thus, a lawyer should not be afraid to hypothetically or alternatively plead defenses which are inconsistent with each other. That is perfectly allowed, as it is alternative, and during trial the pleader may show the best one rather than not stating it in the pleading, and during the trial you waive the best defense because according to the next rule, Rule 9, defenses or objections not pleaded in the answer are deemed waived. Take note that this needs to be correlated to the related provisions. In other words, you don't only see the tree, but the entire forest. Examples. Rule 2, Section 5, where a party may in one pleading state in the alternative or otherwise as many causes of action. Rule 3, Section 6, on permissive joinder of parties. When may two persons or more be joined of plaintiffs or defendants, and how they are joined. They are joined jointly, severally, or alternatively. And Rule 3, Section 13, on alternative defendants. When you are uncertain who is the real defendant, you may join them alternatively, although the relief against one may be inconsistent with the other. So how are allegations in a pleading made? Oh, and before I totally forget, I'm asking you a big favor to please hit that subscribe button. Subscribe to this channel. It is free, and it energizes me to continue what I'm doing in providing you with an alternative way of studying these provisions. I hope you like my audios. If you have any comment or suggestions, please drop them in the comment box or shoot me an email. Thank you. Section 3. Conditions precedent. In any pleading, a general averment of the performance or occurrence of all conditions precedent shall be sufficient. Common usage refers to conditions precedent as matters which must be complied with before a cause of action arises. When a claim is subject to a condition precedent, the compliance of the same must be alleged in the pleading. Remember that one of the elements of a right of action is that before we go to court, we must comply with all the conditions precedent. When you allege compliance with the conditions precedent, is it necessary for you to be specific with those conditions precedent? No. Section 3 says that in every pleading, a general averment for the performance of all conditions precedent shall be sufficient. A general allegation will suffice. Examples of conditions precedent. A. A tender of payment is required before making a consignation, Article 1256. B. Exhaustion of administrative remedies is required in certain cases before resorting to judicial action. Lopez v. City of Manila, 303 Scrap 448. C. Prior resort to barangay conciliation proceedings is necessary in certain cases. Book 3, Title 1, Chapter 7, Local Government Code. D. Earnest efforts toward compromise must be undertaken when the suit is between members of the same family, and if no efforts were in fact made, the case must be dismissed. Article 151 of the Family Code. E. Arbitration may be a condition precedent when the contract between the parties provides for arbitration first before recourse to judicial remedies. The failure to comply with a condition precedent is an independent ground for a motion to dismiss. That a condition precedent for filing the claim has not been complied with, Section 1, Rule 16. Section 4. Capacity. Facts showing the capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of persons that is made a party, must be averred. A party desiring to raise an issue as to the legal existence of any party or the capacity of any party to sue or be sued in a representative capacity shall do so by specific denial, which shall include such supporting particulars as are peculiarly within the pleader's knowledge. When one files a case against somebody, he must have capacity to sue, and defendant must have capacity to be sued. Is it necessary for him to say that plaintiff has capacity to sue and the defendant has capacity to be sued? Yes, because Section 4 says you must show capacity to sue and be sued. It means that capacity to sue and be sued must be averred with particularity. A general statement of it is not sufficient. As a matter of fact, that is the first paragraph of a complaint. Plaintiff Juan de la Cruz, of legal age, single, a resident of Baguio City. There is no presumption of capacity or incapacity to sue. You may say, I am suing as guardian of the plaintiff, that is a representative party, to sue and be sued in a representative capacity. Can you say I'm suing as a guardian? No. Neither can you say I am appointed as the guardian. How should it be done then? I am the court's appointed guardian of the plaintiff minor, having been appointed guardian by the court in this case, based on an order. You have to emphasize that the court appointed you. Section 4 says the legal existence of an organized association of persons that is made a party. It means that the defendant is a corporation existing by virtue of the Philippine Corporation Law. There is no presumption that you are a corporation. That is the reason why facts showing capacity to sue and be sued must be averred with particularity. There is a question in the corporation law whether a foreign corporation can sue in the Philippine court. Under the law, it can sue provided it is licensed to do business in the Philippines. The Supreme Court emphasized that if a foreign corporation is suing somebody in the Philippine courts, the complaint must specifically allege that a foreign corporation is doing business in the Philippines with a license to do. Otherwise, it cannot sue. Under the second paragraph of Section 4, a party desiring to raise an issue as to the legal existence of any party or the capacity of any party to sue or be sued in a representative capacity shall do so by specific denial, which shall include such supporting particulars as are peculiarly within the pleader's knowledge. Example, you are the plaintiff corporation with juridical capacity. I am the defendant. Suppose I will deny your capacity to sue. I will deny that you are a corporation licensed to do business in the Philippines. Now, the law requires me to deny your legal capacity, and I must state the reason or basis of such denial, why you are not of legal age, why you are not a corporation. This is so because the law says that when you deny or when you question the legal existence of a party or the capacity of any party to sue and be sued, you shall do so by specific denial, which shall include such supporting particulars as are peculiarly within the defendant's knowledge. You cannot plead a general statement that you deny. Your denial must be particular. You must be more specific about what you are denying. Section 5. Fraud, mistake, condition of the mind. In all averments of fraud or mistake, the circumstances constituting fraud or mistake must be stated with particularity. Malice, intent, knowledge, or other condition of the mind of a person may be averred generally. Fraud and mistake. Example, in annulment of a contract, fraud is one ground. Suppose the consent was secured through fraud and plaintiff files a case that the defendant employed fraud in obtaining his consent. Is this statement sufficient? No, because the circumstances constituting fraud or mistake must be stated with particularity. The complaint must state how the fraud was committed. It must be described in detail how the fraud took place. Malice, intent, knowledge, or condition of the mind. In the second sentence, why is it that malice, intent, or condition of the mind may be averred generally? A general averment of malice or intent suffices because one cannot describe or particularize what is in the mind of a party. I cannot describe in detail the malice or the knowledge in your mind. I can only say it in general terms. That is born out of human experience. Fraud, on the other hand, is employed openly by overt acts. How you are deceived is not only in the mind. Those are manifested by external acts. Therefore, one can describe how a fraud was committed by the other party. Section 6. Judgment. In pleading a judgment or decision of a domestic or foreign court, judicial or quasi-judicial tribunal, or of a board or officer, it is sufficient to aver the judgment or decision without settling forth matters showing jurisdiction to render it. An authenticated copy of the judgment or decision shall be attached to the pleading. Sometimes a party invokes a judgment of a court or cite a previous case like a res judicata to dismiss a case. Suppose you will ask the court to dismiss the case because there was already a judgment rendered by the court years ago, and you simply say there was a previous judgment. Is this sufficient? Yes, because the law presumes that the judgment is valid, and the presumption is that the court had jurisdiction. You do not have to say that the court had jurisdiction over the subject matter, issues, etc. when it tried the case years ago, so it can be averred generally. However, the amended Section 6 of the rule says an authenticated copy of the judgment or decision shall be attached to the pleading. Therefore, an authenticated copy of the judgment or decision shall be attached to the pleading. So one can just plead the existence of a document made by the government, example official letter of the president or official communication by a government agency. It is sufficient to aver that the document was issued or act done, and attach the document of the same to the pleading. Section 7. Action or defense based on document. Whenever an action or defense is based upon a written instrument or document, the substance of such instrument or document shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit, which shall be deemed to be a part of the pleading. Not every document that is needed in trial is actionable document. So what is an actionable document? An actionable document is one which is the basis or the foundation of the cause of action or defense, and not merely an evidence of the cause of action or defense. Araneta versus Lyric Film Exchange. It is the very heart and soul of your cause of action or defense, not merely an evidence thereof. So a promissory note to collect an unpaid loan is not only an evidence of your cause of action, but it is the very cause of action or foundation of your cause of action. On the other hand, when I have a receipt, the receipt is not only evidence of my defense, but it is the very foundation of my defense. If I would like to sue you to annul a written contract, the contract to be rescinded or annulled is the very cause of my action. But in a collection case, if aside from promissory note, you wrote me several letters of demand to pay, such letters, while they are relevant to the collection case, do not serve as the foundation of your cause of action, although they are also important. What is the purpose of the distinction between actionable and non-actionable document? If the document is not actionable, there is no need to follow Section 7. If it is actionable, it must be pleaded in the manner mentioned in Section 7. Also in Section 8, it is needed to know how to contest the genuineness of the document. How do you plead an actionable document under Section 7? There are two options. 1. The substance of such instrument or document shall be set forth in the pleading, and the original or a copy thereof shall be attached as an exhibit. Or 2. The copy of the document may, with like effect, be quoted in the pleading, in which case there is no need to attach the copy. In the first one, there is no need to copy it. Just mention the substance or features of the promissory note. In the second case, the entire document must be quoted in the pleading. Example, promissory note. For value I receive, I promise to pay B 1 million not later than 1 year from date with 2% per annum. Using the above promissory note, how should the pleading be worded? Two ways of pleading of actionable document. The substance shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit, which shall be deemed as part of the pleading. Party simply cites only important parts of the document, then attach the document. Example, complaint. 1. Plaintiff B is blank of legal age blank. Defendant is blank. Sometime in December 31st, 2017, defendant A secured a loan from plaintiff B for a sum of 1 million payable not later than December 2018 with 2% interest per annum. Copy of said promissory note hereto attaches Exhibit A. The account is now overdue, and despite demands of defendant A, still B failed to pay. So the main features of the promissory note are cited in your pleading: the date when the loan was secured, the amount, the interest. But still, you have to attach a copy of the promissory note, either photocopy or the original. Said copy may with like effect be set forth in the pleading. Document is quoted verbatim. Section 8. How to contest such documents. When an action or defense is founded upon a written instrument or attached to the corresponding pleading as provided in the preceding section, the genuineness and due execution of the instrument shall be deemed admitted unless the adverse party under oath specifically denies them and sets forth what he or she claims to be the facts. But the requirements of an oath does not apply when the adverse party does not appear to be a party to the instrument, or when compliance with an order for an inspection of the original instrument is refused. Does every pleading have to be under oath? General rule, no, except when the law requires it. Example, Section 8, Rule 8. If the plaintiff sues you based on a promissory note, which is properly pleaded under Section 7, and you would like to contest the genuineness and due execution of the note, like when the figure was altered to 20,000 instead of 10,000 only, so there is falsification, then you must deny the genuineness and the due execution in your answer specifically, and most importantly, your answer must be verified and under oath. To contest, you must specifically deny the genuineness and due execution of the document under oath. And B, you set forth what you claim to be the facts. If the denial is not verified and under oath, the genuineness and due execution of the promissory note is deemed admitted. When you say you have admitted the genuineness and due execution of the document, what are the specific facts that you have deemed admitted? The answer is found in the landmark case of Hibbard versus Road, 32 Phil 476. The party whose signature it bears signed it. 2. If signed by another, it was signed for him and with his authority. Pretty Maya told Papa Paul that her housemate, Sexy Regina, wanted to borrow money from him. Paul agreed. Maya signed the promissory note. Regina as principal, signed by Maya. But actually, Regina never ordered Maya to use her name. When the note fell due without payment, Paul sued Regina. Regina denied agency but failed to verify her answer. What is the effect? Pretty Maya becomes agent of Sexy Regina. So the defense of unauthorized signature is automatically out. 3. At the time it was signed, it was in words and figures exactly as set out in the pleading of the party relying upon it. Mr. Quiajon sued Mr. Tiamson to collect a loan of $50,000 on a promissory note. Mr. Tiamson admitted liability but only to the amount of $5,000. Mr. Tiamson used falsification as a defense, but his answer was not verified. What is the effect? Mr. Tiamson admits the genuineness of the promissory note, that it was really $50,000. The document was delivered, and 5. That the formal requisites of law, such as seal, acknowledgement, notarization, or revenue stamp, which it lacks, are waived by it. The Supreme Court said in Hibbard that if you admit the genuineness and due execution of the actionable document, defenses which are inconsistent with genuineness and due execution are deemed automatically waived, meaning any defense which denies the genuineness of the due execution of the document is deemed automatically waived. What are the defenses which are no longer allowed once you admit the genuineness and due execution of the actionable document? The following. The signature appearing in the document is a forgery. 2. In case it was signed by an agent in behalf of the corporation or partnership or a principal, the signature was unauthorized. 3. The corporation was not authorized under its charter to sign the instrument. 4. The party charged signed it some other capacity than that alleged in the pleading, and it was never delivered. 6. The document was not in words and figures as set out in the pleadings. Imperial Textile Mills versus CA. Does it mean to say that when you admit impliedly the genuineness and the due execution of the actionable document, you have no more defenses? No. What are no longer available are defenses which are inconsistent with your own admission of the genuineness and due execution of the actionable document, like forgery, because you cannot admit that the document is genuine and at the same time allege that it is forged. According to the Supreme Court in Hibbard, you may still invoke defenses provided the defense are not inconsistent with your admission of the authenticity of the document. What defenses may be interposed notwithstanding admission of genuineness and due execution of an actionable document, as aforesaid. In the case of Hibbard, the following: payment, want or illegality of consideration, fraud, mistake, compromise, statute of limitation, estoppel, duress, minority, imbecility, usury, statute of frauds, prescription, release, waiver, former discharge, and bankruptcy. May the benefit of the admission of genuineness and due execution of an actionable document be waived? If so, in what instances? Yes, in the following cases, the implied admission is deemed waived: where the pleader presented witnesses to prove genuineness and due execution, and the adversary proved, without objection, the contrary. Uchuk versus Konglipo, 46 Phil 608. Number 2, where the pleader fails to object to evidence controverting the due execution. Ligorda Ko versus Ongsiako, 36 Phil 185. When may a simple denial suffice? Meaning, what are the instances where the denial of the genuineness of the document, though not under oath, is valid? Section 8 says the requirement of an oath does not apply 1. When the adverse party does not appear to be a party to the instrument. Example, Ms. Guadalupe filed a case against Ms. Castillo based on a contract entered by them. But before Ms. Guadalupe filed the case, Ms. Castillo died, so Ms. Guadalupe filed against the heirs. The heirs realized that the signature of Ms. Castillo is forged. Even if the answer of the heirs is not under oath, they can still prove forgery because they are not party to the instrument. 2. When compliance with an order for an inspection of the original instrument is refused. And 3. When the document to be denied is not classified as an actionable document, but merely an evidentiary matter. This is because when the document is not actionable, there is no need to follow Section 7. Normally, the person who is presenting the actionable document is the plaintiff. But suppose it is the defendant who is invoking an actionable document for his defense. He claims to have paid the loan and have attached a copy of the receipt to his answer. The plaintiff looks at the document and realizes that his signature in the receipt is forged. What should the plaintiff do? Based on Section 8, the plaintiff must deny the genuineness of the receipt specifically under oath. In what pleading should the plaintiff file where he will deny under oath the genuineness and due execution of the receipt? Plaintiff should file a reply, and it must be under oath. If he will not file a reply, the receipt is impliedly admitted to be genuine. But the plaintiff may argue that under Rule 6, Section 10, the filing of a reply is optional. How do we reconcile it with Section 8? Rule 6 is the general rule. Section 8 should prevail over Rule 6 because the former is a specific provision that applies only to actionable document. When is the filing of the reply compulsory? When the defendant anchors his defense on an actionable document and plaintiff will deny the genuineness and due execution of such document. Specific denial will be related to Section 10 with Section 5 of Rule 6. Define negative defense. Briefly, it is a defense of specific denial where the defendant denies the statement in the complaint by stating the facts and the reasons on which his denial is based. How is a specific denial done? Rule 8, Section 10. Specific denial. A defendant must specify each material allegation of fact, the truth of which he or she does not admit, and whenever practicable, shall set forth the substance of the matters upon which he or she relies to support his or her denial. Where a defendant desires to deny only a part of an averment, he or she shall specify so much of it as is true in material, and shall deny only the remainder. Where a defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made to the complaint, he or she shall so state, and this shall have the effect of a denial. The purpose of the specific denial is to make the defendant disclose the matters alleged in the complaint which he succinctly intends to disprove at the trial, together with the matter which he relied upon to support the denial. The parties are compelled to lay their cards on the table. Aquinte versus Tibong, GR 166704. So, what are the modes of specific denial? Under Section 10, there are 3 modes of specific denial. First, a defendant must specify each material allegation of fact, the truth of which he does not admit, and whenever practicable, shall set forth the substance of the matters upon which he relies to support his denial. To illustrate, you deny the allegation in the complaint, but you must state the basis of your denial, that it is not true because this is what is true. So you state your own side, your own version. The purpose there is to lay your cards on the table to make it fair to the other side. What happens if a denial violates this first mode, meaning the pleader did not set forth the substance of the matters relied upon to support his denial? That is known as general denial, and it will have the effect of automatically admitting the allegations in the complaint. Suppose the pleader will say, defendant specifically denies the allegations in paragraph 2, 4, and 7 without any further support for the denial. Is a denial specific? No. A denial does not become specific simply because he used the word specific. Curtis versus Ko Bun Kim, 90 Phil 167. What makes a denial specific is compliance with Section 10. The second mode, where a defendant desires to deny only a part of an averment, he shall specify so much of it as is true and material, and shall deny only the remainder. Sometimes an allegation may consist of two or more parts. Therefore, the answer may admit part 1, but part 2 is denied, or the substance of the allegation is actually admitted by the qualification there is denied. Example, plaintiff alleges that the defendant is in possession of the property under litigation in bad faith. Now, the defendant may admit that the property is in his possession, but he denies the qualification in bad faith. Possession is not in bad faith. Based on that, the defendant should say, defendant admits that portion of paragraph 2, that he is in possession of the property in question, but denies that he is a possessor in bad faith, or something to that effect. Third mode, where a defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made in the complaint, he shall so state, and this shall have the effect of a denial. Illustration. I am not in a position to admit or deny because I have no knowledge. How can I admit or deny something which I do not know? Example, plaintiff claims for moral damages because defendant destroyed his reputation. Defendant does not know that plaintiff had sleepless nights, wounded feelings, serious anxiety, etc. Here, defendant cannot admit or deny those. The Supreme Court warned that the third mode of denial should be done in good faith. If the fact alleges such that it is within your knowledge, it is impossible that it is not within your knowledge. You cannot avail of the third mode of denial. Otherwise, if you will avail of the third mode in bad faith, your denial will be treated as an admission. That is what happened in Capital Motors versus Yabut, 32 Scra 1. In Capital Motors, to illustrate, suppose I file a case against you. Defendant borrowed money from plaintiff in the sum of 10,000 payable 1 year from said date. And then you say, I have no knowledge or information. There is something wrong there. What you are trying to say there is, I do not know whether I borrowed money from you or not. How can that be? It is either you borrowed money or you did not. That is why the Supreme Court said in Capital Motors, if you borrowed money, you say so. If you did not, deny it. And then I will allege there, the defendant have made partial payments. Then you will say, I have no knowledge. You do not even know whether you paid me. In other words, it's very evasive. You are trying to be clever and evasive, and if you do that, all your denials will be treated as admissions. That is the warning in the third mode. Negative pregnant. A negative pregnant does not qualify as a specific denial. It is considered to be actually an admission. In a pleading, it is a negative, implying also an affirmative, and which, although is stated in a negative form, really admits the allegations to which it relates. Example, a complaint alleges plaintiff extended a loan to defendant in the amount of 500,000 on July 27, 2016 in Baguio City. The defendant in his answer states, defendant specifically denies that plaintiff extended a loan to defendant in the amount of 500,000 on July 27, 2016 in Baguio City. The answer is a mere repetition of the allegations made in the complaint. The answer is vague as to what it really denies. Is it the existence of the loan that is denied? Is it the amount, the date, or the place? The effect of this kind of denial is an admission, when a specific denial must be coupled with an oath. A denial of an actionable document, Section 8, and a denial of allegations of usury in a complaint to recover usurious interest, Section 11. The allegations of usury which requires a specific denial under oath are 1. Allegations of usury in a complaint, not allegations of usury in the answer, and the complaint is filed to recover usurious interest, Section 11, Rule 8. Matters not admitted by the failure to make a specific denial. A. The amount of unliquidated damages. B. Conclusions in a pleading which do not have to be denied at all because only ultimate facts need to be alleged in a pleading. C. Non-material averments or allegations are not deemed admitted because only material allegations have to be denied. Section 11. While the law says material averment in the complaint, this rule extends to counterclaims, cross-claims, and third-party complaints. Valdez versus Perez, L. 11474. The reason for the rule on specific denial is that if there is a material averment in the complaint and was not specifically denied, it is deemed admitted. However, under Section 11, there are averments in the complaint which are not deemed admitted even when not specifically denied. General rule: material averment in a complaint shall be deemed admitted when not specifically denied. Exception: instances when averments in the complaint are not deemed admitted even when not specifically denied, which is the amount of unliquidated damages in material averments, evidentiary matters because a party is only obliged to aver ultimate facts under Agaton versus Perez, GR 19548, and conclusions of facts of law. Section 11 says allegations not specifically denied deemed admitted. Material averments in a pleading asserting a claim or claims other than those as to the amount of unliquidated damages shall be deemed admitted when not specifically denied. Section 12. Affirmative defenses. A defendant shall raise his or her affirmative defenses in his or her answer, which shall be limited to the reasons set forth under Section 5, letter B, Rule 6 in the following grounds. 1. That the court has no jurisdiction over the person of the defending party, that venue is improperly laid, that the plaintiff has no legal capacity to sue. 4. That the pleading asserting the claim states no cause of action. And 5. That the condition precedent for filing the claim has not been complied with. B. Failure to raise the affirmative defenses at the earliest opportunity shall constitute a waiver thereof. C. The court shall motu proprio resolve the above affirmative defenses within 30 calendar days from the filing of the answer. D. As to the other affirmative defenses under the first paragraph of Section 5, letter B, Rule 6, the court may conduct a summary hearing within 15 calendar days from the filing of the answer. Such affirmative defenses shall be resolved by the court within 30 calendar days from the termination of the summary hearing. E. Affirmative defenses, if denied, shall not be the subject of a motion for reconsideration or petition for certiorari, prohibition, or mandamus, but may be among the matters to be raised on appeal after a judgment on the merits. And Section 13, striking out of pleading or matter contained therein upon motion made by a party before responding to a pleading, or if no responsive pleading is permitted by these rules, upon motion made by a party within 20 calendar days after the service of the pleading upon him or her, or upon the court's own initiative at any time. The court may order any pleading to be stricken out, or that any sham or false, redundant, immaterial, impertinent, or scandalous matter be stricken out therefrom. Under the amount of unliquidated damages, which is not deemed admitted even if not specifically denied. So if the damages are liquidated, they are deemed admitted. Example of unliquidated damage are moral and exemplary damages. To illustrate, damages which I incurred in the hospital, those are unliquidated damages. They are always subject to evidence. You have to prove how much amount you are entitled to. That is why they are not deemed admitted, even if not specifically denied. So if you are claiming 1 million damages for sleepless nights or besmirched reputation and I did not specifically deny such claim, it does not mean that you are automatically entitled to 1 million. You have to present evidence that you are really entitled to 1 million. On the other hand, an example for liquidated damages is an obligation with a penal clause. For example, in our contract, it is stipulated that in case you cannot comply with your obligation, you will pay me 1 million. So if you fail to specifically deny it, then you are deemed to have admitted that I am entitled to 1 million. There is no need for computation because the amount is already in the contract beforehand. The contract itself would show how much I am entitled. On the striking out of pleading, before answering, the defendant can file a motion to strike out a pleading or a portion of a pleading. Striking a pleading means that the pleading will be deemed erased as if it was never filed, or if a portion of the pleading be ordered stricken out or expunged, where a pleading or a portion thereof is sham or false, redundant, immaterial, impertinent, or a scandalous matter is inserted in the pleading, is deemed erased. This is related to Rule 7, Section 3, third paragraph. So, if your pleading contains scandalous or indecent matters, the lawyer who files it may be subjected to appropriate disciplinary action. What if it's the reply is the one which contains scandalous matter? A motion to strike may still be filed by the defendant within 20 days after the reply. And I'm being redundant, but please go ahead and hit that subscribe button if you are somehow grateful of these audios. Thank you.